Hello everyone, my name is Anushri, third year BE in Information Science and Engineering student at Sri Venkateshwara College of Engineering, Bengaluru. Today's topic of my presentation is the Neem patent case under the subject Research Methodology and Intellectual Property Rights. The subject code is 21 RMI 56. First of all, the Neem patent case. India has been nurturing a tradition of civilization for about 5000 years. However, protecting traditional knowledge has been one of the most important issues faced by the country. Traditional knowledge, often referred to as the sacred intangible, traditional knowledge is not protected under the existing Indian Patent Act 1970 due to the absence of inventive character. This includes knowledge passed down through the generations, forming a part of a cultural and spiritual identity. Traditional knowledge protection. Lack of innovation. Traditional knowledge is not considered as innovation or invention under the Indian Patents Act 1970. Therefore, it cannot be patented as per the Section 3(b), depriving it of legal protection. Copyright Act. The Copyright Act of 1957 of India does not specifically provide for the protection of a traditional culture, artistic work, or folklore, presenting challenges in preserving traditional knowledge. Protection criteria. The existing laws require the certain criteria to be satisfied and offer protection for a limited time period, further complicating the preservation of a traditional knowledge. So, let's move on to biopiracy. So, what do you mean by a biopiracy? Illegal exploitation is called as biopiracy. Biopiracy is a process that involves the unauthorized use of indigenous people's knowledge and biological resources by corporations or individuals or in researchers for a commercial gain, undermining the rights of original knowledge holders. So what is the global impact? The global impact is that the extensive exploitation of traditional knowledge by developed countries, as evidenced by significant patent filings, poses a substantial threat to the knowledge of developing nations. What are the difficulties in protecting traditional knowledge? Collective resource. Traditional knowledge protection is usually provided to a community at a large, posing unique challenges due to the collective nature of the resource. So the criteria of a novelty is the most in traditional knowledge is not based on scientific methods, making it challenging to meet the criteria of novelty required for the intellectual property rights. Benefit sharing. Monetary and other benefit sharing is complex and it is often difficult to identify the rightful beneficiaries due to the historical and cultural dynamics. So what are the national and international policies? So we need to understand the national and international policies when it comes to the research. So what is national intervention? The creation of the Traditional Knowledge Digital Library in India has aimed to overcome the challenges related to documentation and availability of traditional knowledge. Global initiatives. Several international policies and conventions have developed to secure the rights of source countries and indigenous populations over traditional knowledge. The neem tree. So what is the historical significance behind the neem tree? The neem tree has been an essential resource in Indian agriculture, medicine and other culture for over 2000 years, often mentioned in ancient Indian texts. What is the global influence of the neem tree? Neem's diverse properties have attracted substantial interest from the global researchers and led to numerous patents internationally. The Neem dispute. Legal opposition. India, along with the global organizations, lodged a legal opposition against the grant of a Neem related patent, highlighting the traditional knowledge associated with the tree. Global impact. The dispute brought attention to the rights of traditional users and the challenge of protecting traditional knowledge from global exploitation. So let's move on to the grace patent under the US laws. Patent compliance and US code sections. So what is patent compliance? When it comes to the grace patent, it's essential to ensure compliance with patent laws. This means following all the necessary rules and the regulations to protect the patent rights and avoid any legal issues. Some key aspects to consider for patent compliance include filing the patent application correctly. First of all, you need to file the patent correctly and maintaining the patent documentation. We need to maintain the patent documentation and adhering to the patent expiration dates and respecting the patent holder's rights. So now what are the US code sections? When dealing with a grace patent, it's crucial to understand the relevant US code sections that apply. These code sections provide the legal framework for patents and govern their enforcement and protection. Some key US code sections related to the grace patent include Section 101, which says patentable subject matter, Section 102, which says conditions for patentability, Section 103, non-obvious subject matter, Section 112, specification and enablement. Analysis of the decision. Opposition. Activist organizations with the support of evidence oppose the Neem patent. Revocation. In 2000, the European Patent Office revoked the patent. Appeal. The revocation was followed by an appeal. Post-dispute developments. India's initiative. So what are the India's initiative after the post-dispute developments? India took the initiative through TKDL, aiding in examiners' search for information regarding the traditional knowledge to dismiss patent grants for existing Indian traditional knowledge. Global implications. The Neem dispute has emphasized the need to protect traditional knowledge and led to the efforts for broader benefit sharing in global context. So that's all for this video. Thank you.